Good afternoon, everyone, and welcome to the CRIPS AI and Data for Lunch webinar. My name is Matthew Holman. I'm a partner here in the CRIPS team, and welcome to this live webinar. We are sitting here in our office studio at Westminster, and we've got 45 minutes of really fun content for you on all things AI and data. Thank you very much for giving up 45 minutes of your lunch to come and hang out with us. In return, we are going to give you a very quick update on all the things that have happened in the last 4 weeks in this fast-moving field of law. I'm then going to do a short update on the EU AI Act because I promised that we'll keep doing that, even though we're still waiting, I think, as I sit here today, we're still waiting for the OG date. I will then talk to you about Experian, and it won't just be me. We have Robin Hopkins, the barrister who represented Experian, in the studio, taking my questions and yours. We'll then wrap up with 3 great things, which is where our research geeks tell you about the fun things that AI has been doing since the last time we met. As always, it's live, so if you have any questions of any kind, please put them into the Q&A box. Please don't use the hands up function because that won't work. If you've got a question, it needs to go into the Q&A. Also, don't use the chat. Right. Let's start. So, without further ado, I'm going to take you into the news. And the first thing, hopefully you can see on your screens, something that says June 24 update. So, I found 8 really cool things that have happened since the last time we all met. The first is the Starmus Festival. Now, I don't know if you've heard of the Starmus Festival. If you haven't, please check it out. It's a festival that took place in Europe earlier on in the month. It was from the 12th to the 17th of May, and the reason I put it on there is it's a festival that brings together tech thinkers, musicians, and philosophers, and all kinds of crazy and brilliant people doing all kinds of brilliant things. And in it was Lord Rees, who is the Astronomer Royal, and Richard Dawkins, who I assume needs no introduction. And in it they were debating the nature of machines, religion, and atheism. Now, it's a weird place to start, right? But the reason I've brought it to your attention is partly because I think most of you will just find it interesting. One of the things that Lord Rees predicted was that machines will overtake humanity as the principal source of intelligence within this millennia. And also then went on to say that it's likely that if that does happen, that intelligent machines would actually start to occupy other planets in completely different parts of the galaxy. So how's that for super cool, slightly Hollywood? The other interesting thing, or one of the other interesting things that happened, is that the US state of Colorado introduced its an AI law for high-risk AI. That's a state law only, it's not a federal law, and it's designed to regulate the interaction between AI systems and consumer technology, obliging AI companies to take reasonable care to prevent algorithmic bias. There are 2 other states in America that have also passed law. If you can't guess what they are, I'll tell you now, it's Utah and Florida. So we'll add those to our ever-expanding graph of international AI legislation. The third thing, if you missed it, on Tuesday the 21st of May, the EU member states and the Council passed the EU AI Act. So that was the 21st of May. I haven't had a chance to check today, but as of Friday, we were still waiting for a publication in the OG, which is the official journal of the European Union. Once it's in there, we'll have an exact date for you for when it comes into force. Also, on the same day, the ICO concluded its 3rd consultation on Gen AI and launched its 4th consultation, which is all about data subject rights and generative AI systems. Once again, there is a CRIPS team working on the response to this consultation. Watch this space for more publications. The EDPB OpenAI Task Force published its initial findings. That was on the 23rd of May. This is a group of the European Data Protection Board who were set up to try to start carrying out investigations into OpenAI. Its preliminary report. It's really interesting. They're obviously quite critical of OpenAI, but they don't seem to reach too many conclusions at this stage. What they have done, helpfully, is set out in an appendix all the things they've asked OpenAI to tell it. And we await the hopefully much more detailed follow-up publications of that. I'm going to keep moving on because time is precious. The ICO fined PSNI. If you don't know who that is, it's the Police Service Northern Ireland. The fine was for £750,000 for a data breach in 2023. This was PSNI releasing the details of all officers on the force to the internet, which was then caught by sectarian groups and put all of the officers' lives in danger. One of the big things to take away from that case is that the ICO says in its enforcement notice that the fine would have been £5.6 million, but for the fact that PSNI is a public authority. This is a point of great debate. It sounds, if you're in the private sector, that sounds like a massive discount and it feels unfair. If you're in the public sector, it perhaps feels like a generous use of the ICO's regulatory powers. I think we'll be debating this in more webinars to come. But let's keep moving, because if you missed all of that, you surely didn't miss the fact that on the, when was it, 23rd of May, Thursday the 23rd of May, Rishi Sunak announced a general election, and that meant that the DPDI number 2 bill has gone, along with the bill we were talking about before. We wait to see if these bills will be resurrected in the next parliament, but for now it's all over to us to decide who's leading British democracy in the future. The 7th of July will be the same week as the next webinar, so we won't actually know who is going to be in Downing Street by then, but hopefully I was about to say something controversial, but I won't do that. Happy birthday to the GDPR also happened in the last 4 weeks. So you may have missed it. It was a Saturday. The GDPR was 6 years old. It feels like congratulating a child. So that is all of the roundup I have for you on all things data protection and AI in the last 4 weeks. So we will, at some point in the next webinar, we'll do a roundup of all the amazing things that have happened between now and July. Hopefully you found that useful. The next thing I want to take you to is the EU AI Act, because we promised last time we did a very quick skim of it and then we moved on to talk to Lord Holmes about the Private Members Bill, the AI Act. Instead, what we're going to do now is look at a bit more detail around the high-risk AI and the prohibited AI types. These are two of the designated types of AI. So let's start by looking at Article 5. Some of you asked for a bit more detail on this, and I thought it was really good that you did. Thank you for doing that. There are 8 types of AI prohibited by the EU AI Act. I've listed them on the screen for you there. I won't read all of them to you because that would be really boring. Instead, I'll pick out a couple that I think are really interesting. The first is subliminal manipulation. So the use of AI to affect your thinking in a subliminal manner. Obviously prohibited and absolutely the stuff of Hollywood, but I'm glad that the EU legislature thought it worthy of writing down. Some of the others are quite straightforward and obvious too. Exploitation of vulnerabilities, biometric categorization of individuals based on sensitive characteristics. These are all things that could be quite harmful. At the bottom, creating AI face scanning systems to expand FRT, that's facial recognition technology, databases through untargeted scraping of images from the internet. Might as well say, Clearview, you can't work here. One of them that I wanted to pause on briefly was number 4. This is general purpose social scoring based on personality characteristics leading to detrimental or unfavorable treatment. I thought it was worth actually putting it up on the screen because it's the least precise of all of them. Quite a few of them are very particular. You can look at them and, for all of you who are listening, they're in-house clients or working in different companies, you can look at it and pretty easily say we either are or aren't caught by them. But Article 5 is more vague. It says the placing on the market and putting into service or the use of AI systems for the evaluation or classification of natural persons or groups of persons over a period of time, based on their social behaviour or known, inferred or predicted personality characteristics, with the social score leading to either of the following, and then it says essentially detrimental or unfavourable treatment. Now, those are things which are less precise and less clear, and actually a lot of organisations do carry out widespread analysis and analytics of groups of individuals. If there's a possibility that it could lead to detrimental or unfavourable treatment as set out in subsections 1 and 2 of Article 5, then there's a risk that it could be prohibited. I'm going to take us on to high-risk systems, because prohibited systems are absolutely that. They are prohibited, you can't do them, there are very few, if any, carve-outs. But high-risk systems are permitted under the EU AI Act. So the first and obvious question is, well, what is high risk? The answer to that is found in Article 6.1. It says that anything is high risk if it's a safety component or part of a product safety system. And it says that anything is high risk if it's listed in Annex 3. Now, Annex 3 is fairly long, and I've taken a summary of the bits that I think are most interesting. We have biometric systems or emotional recognition. We have critical infrastructure, education. So any of you who are working in an education institution should know that the use of artificial intelligence in that institution is considered high risk per Annex 3 of the EU AI Act. It expands by saying AI used in admissions, evaluative learning outcomes, assessing appropriate levels of education, monitoring and detecting prohibited behaviours. All of these things are high risk. It's also high risk in employment. And that, for most of our audience, is going to be very relevant, because the use of AI for recruitment or making decisions about the workplace, it's the kind of area that there's a lot of research going into right now. And I know a lot of organizations are thinking about using AI to help sift CVs or to deal with the HR process. That, again, will be high risk. Some others include access to essential services such as credits, credit scoring, hashtag Experian, migration and border control, and administration of justice and democracy. If you're doing anything that ticks any of those boxes, then there are some very particular things you have to do. They are set out in Articles 8 to 15. It would take me probably an hour or so to summarise it to you, but instead I'm going to do it in about 2 minutes. So forgive the speed and brevity. What you see in Articles 8 to 15 looks and feels very much like the governance processes from the GDPR, except that the context is clearly different. We have fundamental risk impact assessments. They sound exactly like what they are. If you're used to DPIAs, then doing FRIAs will feel very similar. Technical documentation and record keeping, including logging activity, risk mitigation systems, etc. Human oversight is very important in high risk, and actually the ability for humans to interject in decision making, to correct wrong decision making, to deal with complaints is a big part of the governance structure. Accurate, secure and robust models are important, and transparency regarding output of the model. I mean, transparency we could pause and talk about all on its own. There's a whole separate subsection of debate around the black box nature of AI and our ability to determine how things are undertaken by systems that are not able to communicate what the calculations and processes are. Transparency is also key in the world of data protection. So if you're familiar with that, and we're going to talk a lot more about it in the context of Experian shortly, then you'll have at least the beginning of an understanding of what the EU AI Act is aiming towards. Most of the high-risk AI duties fall on the developer and on the deployer of the AI system. We'll talk more about those designations before, but if you can remember back to the last webinar, there were the four different types of user, if you like, and developer and deployer are the two for whom high-risk AI is the most important. If you're in those categories, so if you're creating and developing AI, or if you're the organization putting it to use in your organization, then you are the deployer, you need to comply with these governance processes. It's 15 minutes in, and that means we're going to pause. I'm going to take a breath, and we are going to talk about Experian. Now, anyone who's been working with me for a while will be sick to death of listening to me talk about Experian, but it has been one of the most fascinating data protection cases of the last couple of years. We're going to show you what happened briefly, and then we are going to do Q&A with Robin Hopkins. But first of all, let me take you through a chronology of the case, starting with stage 1. So, hopefully on your screens, any second now, you will be able to see a slide that says stage 1. Stage one of the ICO Experian case is that in October 2020, the ICO issued an enforcement notice against Experian. Experian is a credit reference agency, if you weren't aware, and they were processing the personal data of the entire adult population of the UK, circa 51 million data subjects. In addition, Experian operated a separate business called EMS, Experian Marketing Services, which processes the data of data subjects and essentially conducts marketing activities. It collects 13 actual attributes, 49 derived data points, and 370 model points. It then sells all of this to clients as a marketing service. The ICO alleged various breaches of the UK GDPR, including Articles 5.1a, 6.1 and 14, and it instructed Experian to cease trading until those issues were resolved. So that was stage one. At that point, a lot of people in the data protection world were shocked and stunned because this was one of the first times we've ever seen the ICO try to suggest that a business should effectively cease trading a particular division until it sorts its Data Protection Act out. Unsurprisingly, Experian appealed. Stage two, the hearing took place in January and February of 2022, and the tribunal overturned the decision on almost all points. It published a brand new SEN, supplementary enforcement notice, that basically just required Experian to make a few minor changes. It found that Articles 5.1a, 14 and 6 had not been breached. It was extremely critical of the ICO's witness evidence. I won't read the whole of paragraph 1 through 6 there, but essentially it is saying that that witness said that it gave opposite evidence to what was in the witness statement. The reason I've flagged that up is that it's very hard to overlook the significance of that witness evidence in the outcome of the case as a whole. The final stage, stage three, the ICO appeals to the upper tribunal. The hearing was in February this year, and the decision was in April. The upper tribunal dismissed the ICO's appeal, upheld the lower tribunal in all respects. The upper tribunal was very critical of the lower tribunal's methods, but not its outcome. You can see some of the quotes on the screen there. It said, the FTT's decision is neither well structured nor well reasoned, but for the reasons stated, we are satisfied there is no error of law. And then it said, we conclude by thanking counsel for the considerable assistance that they have provided to us, and observing that many of the points raised in this appeal could have been avoided if the FTT, that's the first tier tribunal, had provided a timely and better reasoned decision. They thanked counsel, and I'm going to say hello to him. Please welcome into the studio Robin Hopkins. Robin is a barrister at 11 KBW and acted in the Experian case representing Experian. Thank you very much for coming into the studio.
Thanks, Matt. Good to be here.
It is tradition that anyone who comes on a CRIPS AI and Data for Lunch webinar is asked a series of annoying, random and slightly irritating quick-fire icebreaker questions. Is that okay?
Go for it. Let's do it.
We're going to mix it up this time, audience, and I have on these cards a series of statements. You have to finish each sentence with a word of your choice, and you've got 40 seconds to do it in. Are you ready?
I am.
If I were participating in the Olympics this summer, my chosen sport would be?
Triathlon.
The best biscuit to dunk in tea is?
Chocolate digestive.
Excellent choice. If I wasn't a barrister, I would be a?
Monk.
A monk. Before leaving the house each day, I always?
Caffeinate.
The first thing I do on a Friday after work is?
Visit pigs.
The best place I have ever been on holiday is?
Cape Town.
Clearly the greatest film of all time is?
Back to the Future.
Absolutely. My favourite part of London is?
Hackney.
I drive a?
Bicycle.
A bicycle, of course. And you did it all with 1 second to spare. Congratulations,
Excellent.
4 points on the icebreaker questions.
Thanks, Matt.
We're obviously here to talk about Experian and the significant case that it is. As a case, it seemed really interesting because you had this bombshell first moment where the ICO issues this massive notice in October 2020, effectively saying, Experian Marketing Services, you need to cease trading. It wasn't just like they said, here's a fine, you've been naughty, pay the fine. They were really going after a business section to try and, it feels like it, to shut it down. Then you had this first tier tribunal decision where the witness performed really badly, and the tribunal said we have no choice but to basically overturn everything here. And then you had this other bombshell with the upper tribunal in April saying, well, we're going to uphold that decision, but we think the rationale and the delay was really detrimental and bad. We didn't like any of that. Was this as fun a case to work on as it looked like from the outside?
Oh, absolutely. It was a really fun and interesting case. And that's not just because I and my leading counsel were on the winning side, and my experience is that winning is a bit more fun than losing. But for a whole load of other reasons, it was a great, fascinating case for mixing the data protection legal principles that sit there in law and that have us scratching our heads about, what on earth do they mean? What does transparency mean? For example, what do you actually do to achieve it beyond your privacy notices? That kind of difficult legal stuff, but in a very concrete setting, applying that to a specific business and what it did with data. Had all the advisor plus the litigator in me, having a great time with this case, cross-examination, legal principles and argument. It was also novel, lots of stuff that even the upper tribunal remarking, we don't seem to have any authority on this, so we'll see what we make of. We'll make a start. And it was, in a significant sense, business critical for a division of a company that believed strongly in what it was doing and that it was compliant and was prepared to come out and perform strongly with witnesses and make its case.
Because of all the shock moments and because of all the plot twists, one of the things that is possibly worth thinking about is whether or not this case actually makes it into our day-to-day data protection orthodoxy. Is it the kind of case that we should be routinely referring to if we're advising, or should we dismiss it and disapply it because of all of the novel and unique factors in it?
Well, it's worth recognizing that there are fact-specific parameters here, so don't rush for the Experian judgment as your go-to dictator of all answers to transparency questions, no matter what the context is. You mentioned this in your outline, but it's about offline marketing, so we're not talking about cookies and web-based marketing practices. It's about predictive data. For example, are you statistically likely to have a dog rather than do you in fact have a dog? And the impact for you is whether you get a dog food leaflet through your letterbox rather than a text message or an email or that kind of thing. So it has its specific parameters, but it would be wrong to say, well, because I don't fit that, all of this is irrelevant. The upper tribunal is getting to grips with what transparency means in the UK GDPR for the first time, how you fit Article 5.1a with Articles 13 and 14, what one adds to the other. It's trying to distill the principles, and whilst it can't give you, outside of its own facts, the answer in your different context, what it does is provide a sort of case study or a roadmap for how to think through what the transparency answers for different contexts might be.
Is it worth explaining to the audience briefly the difference between the first tier tribunal and the upper tribunal for those who aren't initiated? What do those tribunals do and how do they work together?
Yep, good point. So the first tier tribunal, which is where you go on appeal against an ICO enforcement notice or a monetary penalty notice, that is, it's got a judge who is a lawyer and 2 wing members. They make a decision afresh, so they look at the whole thing from scratch, not like a judicial review of whether the ICO went wrong on points of law. That makes its decision, but that decision has no force of law. It applies only between those parties, and it doesn't otherwise have any legal precedence. It doesn't set new law. The upper tribunal, where you go after the first tier tribunal, that has the same legal status as the High Court in its judgments, so it's points of law only, and that does then become binding legal precedent unless there's something above it. And in this case, Mrs. Justice Williams, an experienced High Court judge, was in the chair on this 3-person judicial panel.
Excellent. Well, in light of that then, it's probably worth talking a little bit about the significance of transparency in this case, and in particular paragraph 95 of that judgment. That decision, one of the things the decision did was look at transparency, essentially say we don't really have any judicial authority on transparency. So what we're going to do is articulate one for ourselves. Do you think the upper tribunal's new expression of transparency is a radical departure, or are they really just reiterating old stuff in a new way?
I don't think it's a radical departure. I think it's interesting because what it does is start to distill fragments that we find in ICO guidance, EDPB guidance, bits of the legislation that don't leap off the page as explaining how they fit together, and trying to help us with your paragraph 95, which, by the way, is if you only have 5 minutes to read anything about this and you're going into a meeting, go to paragraph 95, and that's where that will help you emerge in the meeting sounding learned. What it does there is help us with principles like, okay, the GDPR's got Article 518 talks about transparency, but never tells us really what that means. Later on in the GDPR, we've got Articles 13 and 14, privacy notices. Is that what transparency means? Or does it mean something extra and additional? Helps us by talking through how you would do your analysis. I mean, the short answer is Article 518 does add something, but you can never pin down outside of the facts of a particular case what exactly does it add. And it's also useful not only on what those concepts mean, but how you go about delivering your privacy notices, your transparency information in a compliant way.
It's probably worth moving on to that. We'll take questions from the audience in a second, by the way. Thank you for your questions already. If you've got more, fire them into the Q&A section on Zoom. One of the things that the tribunal did in assessing transparency is say, well, it's more than just privacy notice in the sense that it's partly about that, but it's also about ease of access. Robin, a key part of the case is the tension between those things. The upper tribunal says that the ease of access to privacy notice and the actual content of the notice are just as important as each other. Do you agree with that?
Absolutely. I think that's we've got that now, confirming what I think all of us who work in this field would be telling clients already. What's the content? And in the Experian case, the ICO had attacked the content of Experian's privacy notices and said you are not explaining sufficiently clearly what you actually do with data. But it had also said you are not delivering these notices properly. There are big cohorts of people who either don't get this at all, they never receive your notice, or they receive it in a sort of buried way where it means that realistically they're not going to engage with this. That was the ICO's essential concern.
So if you are listening right now, if you were listening to this and you are an in-house lawyer and you've got in-house clients and your in-house client comes to you and says, listen, we're going to do X, Y, Z, and I want you can put it in a privacy notice if you like, but you need to bury it. You need to make it hard for people to find. I don't want them to read it because it's going to put them off. What would you say to any organisation in that context in light of Experian?
Yeah, well, certainly the wrong way to read Experian is that as long as you put in your privacy notice somewhere, the stuff you do, everything will be fine. In fact, Experian turned very significantly on the fact that we, for the Experian team, could say that the heart of this case is profiling for marketing purposes. And if you want to find out, if that's the important thing for you to find out, you get it on page 1 of our privacy notice. We tell you. You don't have to go 7 layers in. And if we are sending you our privacy notices or making sure you get it via third-party data suppliers, you get our privacy notice pretty quickly within their materials. If we had come before the first-tier tribunal and the upper tribunal saying, yes, tribunal, we do convey this information, you have to spend about 5 minutes rummaging through hyperlinks in order to find out what we actually do, that would have made for a very different case.
Indeed. So another big takeaway, the ease of access just as important as the quality of the content. Another thing that happened in the case was the upper tribunal tackled for the first time the issue of providing a privacy notice by hyperlink. There was a lot of debate about Article 14 and whether or not having the hyperlink was equivalent to having the privacy notice. If you give someone a hyperlink, do they actually have the notice or just have the means to get to the notice? All of that was argued, and in this case the tribunal said that it was okay, but they were quick to say that it hinges on content, it hinges on context. do you think there's ever a scenario where using a hyperlink to communicate a privacy notice isn't going to work, or do you think it works most of the time? What's your view on that?
I think again, we shouldn't read Experian as green lighting. Hyperlink means everything's fine. In fact, it seems, reading between the lines, clear that there will be plenty of cases where providing a hyperlink is not going to work. An example might be you're doing something that the data subject wouldn't reasonably anticipate you doing with their data because they didn't understand you to be that sort of business. And the only way you tell them about it is with a very long, dense privacy notice, which you put in 6-point type at the bottom of a lengthy contract or email. Yep. That's probably going to be difficult territory.
So if you are an in-house lawyer or working as a DPO out there and you are being asked questions about sending privacy notice via hyperlink, it's just worth thinking about Experian again. Experian is a good case to look at for the qualitative test as to when it's going to be fine and not. It will give you an inkling at the least, as to the kind of things that the tribunal, possibly even the ICO, will be taking into account when looking at whether sending a hyperlink, privacy notice by hyperlink, is compliant with GDPR. Another question I want to ask you is that a very big part of the case was the debate about whether Experian's processing was shocking or surprising to the average person. And I don't think it would be unfair to say that most people haven't got a clue what Experian is doing with their data for marketing purposes. The ICO said that it was shocking or surprising to the average person. The first tier tribunal said that it wasn't, and the upper tribunal didn't overturn the FTT's evaluative assessment of that. The upper tribunal concludes that an objective reasonable expectation test was correct and a subjective are you surprised test was wrong. Do you think that's the right outcome? Were they right to frame it in that way?
Well, I'm going to say yes, given that I was part of the council team arguing for them to do that. But it's an interesting tension. Surprising was the key word that the ICO focused its enforcement on. It would surprise most people that a company that they see as a credit reference agency was also doing this detailed marketing profiling. That was the ICO's key point. There was debate, legal argument about, well, is surprising really a legal word? What are you supposed to do with it as a lawyer and when you're fighting about enforcement notices? It doesn't have legal footing at all. In the end, the upper tribunal preferred a sort of reasonable expectations analysis. Now, that's not the same as the law of privacy, where where the question is, do you reasonably expect something to be private? But it is asking really, what would the objective person, the notional man on woman on Clapham omnibus sort of person, reasonably anticipate would be done with their data in this context? That's I think one of the takeaways would be, if you're running through your own privacy measures, transparency measures, don't abandon the idea of surprising. We know what that means. It can be a helpful human test, but also ask yourself, is what we do something that the data subjects would reasonably expect? The less comfortable you are with that, the more prominent and clear you should be in telling them about it.
I've lost count of the number of times I've had conversations with many clients and organisations about the sucking of teeth test, which is, if someone suggests we're going to do a particular kind of processing and your response is to suck your teeth and go, sounds bad, then that is sort of, it's gut feeling reaction, isn't it?
Absolutely, and there's quite a lot about this case that turned on to what extent is the processing, the building of these marketing profiles, which make all these assumptions statistically about people so that we can decide who gets pet food leaflets or whatever. To what extent is that an intrusive activity? Now that is something of the gut feel instinct rather than hard-edged law about that. And you mentioned it, Matt, at the outset, where the ICO's evidence on why it thought Experian's processing was intrusive fared badly at first-tier tribunal level, and it was quite that creates a certain footing for the whole case.
I'm going to take a question from the audience. Thank you for those who've fired them in already. one of them crosses over with something I wanted to ask you actually, which is that the Experian case has big ramifications for marketing. It's all about marketing. Do you think that legitimate interest is the right lawful basis for granular marketing activities? And because this is only in the context of Experian offline, should we change our thinking if we were talking about marketing that is online?
So there's certainly nothing in the Experian judgment that suggests legitimate interests is no-go territory. And in fact, even the ICO's enforcement notice that it wasn't in terms shutting down this bit of the business, but in practice was making it very difficult to operate this business without additional transparency measures. Even that didn't say you cannot rely on legitimate interests. So we shouldn't come away feeling too squeamish about it as a dead duck in marketing terms. The point you emphasised though about what about in online or more real-time, more actual data type contexts, is legitimate interests does it have a future as a processing condition? I mean, there I think the mood music from CJEU judgments against the big social media companies is quite negative and making at least certain types of very, very targeted online marketing much more difficult to justify based on legitimate interests.
Absolutely. We've talked previously before about Meta as well, and there's a comment in here about Meta. There is the case coming next year in the UK. Do you want to touch on that a little bit and how that's relevant to what we're talking about now?
Well, I'll just briefly say what it is that in 2025 there is due to be a trial in the High Court in the UK on the question of whether the kinds of online targeted or personalised advertising you see on a social media service like Meta counts as direct marketing for the purposes of Article 21 of the GDPR, because that, as most of us will know, brings objection rights, entitlement to say no thank you for that kind of processing. So that will be,
Article
I think,
21.
exactly, well done. I think that will be a useful judgment to test, or to see the judiciary engaging with how online targeted personalised advertising works and what it's how you translate that into GDPR principles.
We've got just a minute left, so I'm going to, before we move on to three great things, I'm going to ask another question from the Q&A. In terms of transparency in particular, do you feel the upper tribunal decision reconciles itself with the TikTok case? For those, when there might be people on who don't know about TikTok, we've done a session on TikTok already, but do you want to talk a little bit about that, and is there any obvious overlap?
Well, I don't want to say too much about either the Meta case, where I'm part of the legal team in that case, or the TikTok case, because I'm involved in that challenge to the ICO penalty also. So I won't get too much into the facts. I will politely duck.
Good
but
ducking, well done.
TikTok is the ICO's monetary penalty in TikTok is more about the content of the privacy notices. Does it match up to what Articles 13 and 14 require? Less about the more Experian, vague, general, what does Article 5.1a add? And in that sense, Experian is that sort of top-up differentiation. What does the general transparency duty add to the more particular ones?
Excellent. Let's wrap up there. Thank you very much, Robin, for coming in and taking my questions and those of the audience as well. I'm very grateful. We are going to do three great things, and we are down another AI elf. This dropping like flies at the minute. It's terrible. For those of you who follow Louis on LinkedIn, you'll know that he has moved on to pastures new and is traveling the world and doing all kinds of amazing things and taking some time out. So Louis, if you're listening, hello to you wherever you are. And Alice, you are our AI geek. Thank you very much for doing all of the research and stuff that you've done to make this possible, by the way. And for giving up some time to come and sit on the webinar. You've got 3 things that you found for all of them, haven't you? So you've been doing all of the AI elving yourself.
I have, yes, Matt. I'm happy to be here.
What have you found? What's AI been doing in the last 4 weeks?
So the first thing that I found is that OpenAI have released a new model, and this is a GPT-4o, and the O stands for Omni. So this model can process any combination of text, audio, image, and video inputs. And one of the most notable improvements in this GPT model is its speed. So it can it's designed for real-time interactions, and they've released a set of videos, and one example that's been shared is a real-time translation of a conversation between an English speaker and a Spanish speaker, where the GPT model allows the conversation to be translated in real time as a universal translator.
It's like Star Trek in real life.
Exactly.
Amazing.
Yeah, exactly that. The Star Trek universe has now become a reality for us.
At last.
So that's an excellent update. And
Awesome.
the second thing that I found is that the engineers from the University of Washington have developed an AI system which allows you to wear headphones and it will isolate a single speaker in a room of a lot of noise and various people talking, and the machine learning software can isolate that one speaker's voice and allow you to just hear that. Wow. And it can analyze the vocal patterns to recognize which speaker it is, and you can walk away from the speaker and still continue to listen to them.
That's very cool.
Yes, so the system is still in its prototype stage, so we can't yet have a commercial product, but in the future that's something that would be great. For example, in a busy London pub, you could just hear one person talking.
Fantastic. What's your third one?
And the third is a new NHS technology. So they've developed and deployed their own cloud-based AI technology, and it's called Osiris. So when a patient is referred for radiotherapy, it typically takes a doctor between 20 minutes or 3 hours per patient to get the scans ready. Really? And it's quite a complex but quite routine task. So that's something that AI can assist with. So with an oncologist in control, they can check the scan that's been through the AI system, and in that case, it's finding that it's allowing doctors to be approximately 2.5 times quicker, and it basically means that patients can get their treatments a lot more quickly and improves the likelihood of finding a cure.
Amazing. Robin, you are our special guest, and I'll throw one last question at you, which is which of those 3 new developments do you think are most impressive to you? Which one would you pick as the best? You've got OpenAI, GPT-4, you've got headphones in a London pub, or you've got oncologists diagnosing cancer more quickly?
Well, social good and moral terms, I think we're going to go for the third one, aren't we? Though the Star Trek scenario, that one I suppose grabs the interest and has the more sort of sci-fi, possibly dystopian elements of how it could be used, isolate voices in big context.
Maybe in webinars to come, we'll try and do a webinar with it live, and I'll maybe try and interview someone in another language, and we'll see if GPT-4 can do it. That'd be really cool. Do you speak any other languages?
None that are going to help right now.
It is 1:15, which means it's the end of the webinar. Thank you very much for taking the time to tune in. I hope you found the discussion about the EU AI Act useful. I hope you found the roundup of all the things that have been going on useful too. And most importantly, I hope you found the Experian Case Digest helpful. It's really hard to understate the importance of it. If you're advising on the duty of transparency, please remember to at least have a look at Experian in paragraph 95. It's going to inform how we talk about transparency in the world of GDPR for a couple of years to come at the least. We are back on Monday the 1st of July at 12:30. We'll be talking about the PSNI breach. We'll be looking at ICO fines to date in 2024 and doing some general discussion on trends. And I will be talking about the EU AI Act, limited risk and low risk AI types. That's all the time we have. Thank you very much for watching. I hope you found it useful. See you in 4 weeks.